Good afternoon, everyone, and welcome to today's webinar on the European Union's General Data Protection Regulations. Today we have Barbara Dunn O'Neill with us to walk us through what the GDPR means for your companies. Barbara is a partner with the law firm Barnes & Thornburg, who represents FPSA. My name is Dolores Alonso. I'm the VP of Membership here at FPSA. This webinar is being recorded, so you and any of your colleagues will have access to it in the members only section of the FPSA website after today. The slides that Barbara will be referring to are also included as an attachment for your reference. And in addition, there's some information on one of our affinity programs sponsored by Barnes & Thornburg. It's our discounted legal services program for FPSA members only. Barnes & Thornburg specializes in many areas such as contract review and negotiations, intellectual property, customs compliance, and trade regulatory counseling, labor and employment, and cyber liability, and risk management, to name a few. So if you're interested in learning more, just let Barbara know, and she'd be happy to give you more details. So before I pass this over to Barbara, I just want to cover a few housekeeping items. All attendees are muted by default, but you'll have the opportunity to submit questions to Barbara today by typing them in the questions pane of the control panel. Send them anytime, and we'll address them during the presentation or after. So thank you, everyone. Let's get started. Barbara, I will pass this over to you now.
Super. Good day, everyone. It's nice to be with you. It's a delight to be part of FPSA and to get to work with members. And so today is all about you and your questions. And those of you who are somewhat familiar with the regulations will use the term GDPR today. Those of you who are not familiar, everyone has their own angst of pain here in trying to comply with what are incredibly complex regulations, and incredibly burdensome regulations and potentially costly. So I always have described this, as many folks do, of drinking out of the fire hose. Organizations large and small, for-profit, not-for-profit, have been working over the last many months and will continue to work toward compliance. So I don't want anyone on the call today to fret if you feel like, oh gosh, we haven't done this or that. That's exactly why we're having this webinar today, is to give you some baseline information. And just to start off with a couple of things about the GDPR itself. These regulations went into effect on May 25th, just a few months back now. In fact, it'll be 2 months next week. And since their inception and they were announced, again, it's caused stir across the globe. A lot of folks think of these as, well, that's just an IT problem. That's just an IT issue. And the reality is they're really anything but just an IT issue. Yes, your IT team should be involved. Yes, there are certain protocols and standards when it comes to data security and the rest, but primarily it's the business team within your companies who need to be familiar with these regulations. You don't need to know chapter and verse, as I always say to clients. You just need to know enough that that little red flag goes up or the light bulb goes on where you know you need to follow up with something. So as Dolores mentioned, we're recording the webinar today. I invite you, as you work with your team, to train folks. Please consider using the webinar and our materials, and of course, if you have questions, let us know. So the premise of these regulations are really founded on and based in human rights. So the European Union considers your personal data, that is the data that you personally own, your name, your address, your picture, etc., to be a human right. So pause and think about that for a moment. Human rights, like so many other, that's a very high significant threshold, higher than any other governmental entity has ever classified personal data. So you start with the premise that it's a human right. It's a human right that I have the right to control use of my personal data. And that is, in fact, the premise of these regulations. So the reason the standards are set so high and the penalties are set so high is because the European Union and the member countries see this as a member right, as a human right of those citizens within the member states. Now, I'll pause as I just said the word citizens. There's definitely a lot of confusion as to who do these regulations apply to. Well, they apply to people, not companies. That's the first thing to understand. And the regulations actually speak to residents of European Union member states as opposed to citizens of European Union states. So it's possible that a U.S. citizen living and working abroad in Germany, for example, could be covered by these regulations, as Germany would be their primary residence. It's also conceivable that a German citizen working abroad here in the United States may claim the U.S. as their primary residence, and therefore the regulations don't apply to them. And so this is a source of a lot of consternation for groups and companies to determine really who this applies to. And as we get further into the regulations, it's something to keep in the back of your mind. Also pausing for a moment to speak to the European Union aspect of it and the Brexit, impending potentially Brexit, that the United Kingdom has essentially announced that it will have harmonizing type regulations which will be equivalent to GDPR. So UK would be included in the mix as we look at whether it's an EU resident or whether it's a UK resident. So it's a human rights law, and I mentioned that term personal data. A lot of times when I speak with a client might refer to what we use a lot in the United States, which is personally identifiable data, PII. And that often is your name, birth date, social security number, etc. Personal data under these regulations, under GDPR, is significantly broader than just PII. Personal data is really anything that you might think of that could identify a person, from your name, your address, your phone number, email address, photograph, face print, fingerprint, genetic makeup. All these types of things are all potentially personally identifiable and therefore fall within what the EU calls personal data. So we have to start with the presumption that personal data is about as broad as you can get in terms of what type of information that it covers. And these regulations really focus on the processing of personal data. So if your company, for example, holds data of an EU resident, these regulations address what your company can do relative to quote unquote processing the data. And just pausing on this point, processing is about as broad as you can imagine. It's everything from manipulating the data to sending invoices, to sending emails, all the way down to even viewing the data. So it's a bit mind-blowing in its scope, but again, suffice to say that both the term personal data and the term processing are equally broad. So in most instances, likely data you're holding on your system would constitute processing, even though you may not have used it or touched it recently. Again, we'll talk about that a little bit. These regulations follow EU residents wherever they travel in the world. So, that's been a source of consternation for a lot of organizations in compliance, because the issue becomes, a lot of times, how do I know someone's primary residence is in the EU? And it's really self-selecting on their part. They have to tell you, yes, my primary residence is in the EU. And so whether they're traveling internationally, say traveling to the United States, checking in at a hotel in the United States, likely will be asked questions about this, because these rights follow the individuals no matter where they go. So, there are a number of pundits out there who have questioned and challenged how a U.S. court might enforce a judgment against a U.S. company for a violation of these regulations. And it's certainly complicated, and it's certainly not yet decided, but it raises those types of issues when you consider that these laws and these regulations follow everyone as they travel around. So these regulations are major differences than what we have here in the United States. In the United States, some states have data privacy laws, and those of you listening in from California today, and those of you who are familiar with what California just passed at the end of June, is a Consumer Privacy Act. And so there's a lot of buzz on the street that this law was going to be equal to or equivalent to the GDPR regulations as they would relate to a California resident. And the fact of the matter is, this law is much more narrow in its scope, in that it only applies to for-profit companies, and the companies have to have at least $25 million in gross annual revenue, or have data on over 50,000 California consumers, or have 50% of the revenue that comes from selling consumer data. So this law may apply to you, but yet it's not even coming into effect until January of 2020. So some of the principles of this law are similar to GDPR, but GDPR, on the other hand, covers every type of organization: large, small, for-profit, not-for-profit. And we'll walk through that in just a moment. But in case you're curious about the California law, please let us know at the end of the webinar, as we have a summary of that we put together, and we can share that with you. So again, it's been a massive challenge for U.S. businesses to comply. I'm frequently asked whether there are any grandfathering provisions. In other words, data that you had in your company database up to leading into May 25th, 2018, is that data grandfathered in? Meaning, do we have to have the regulations comply to that data, or are these regulations just applying going forward? And the answer is, it applies to everything, that there is no protection or grandfathering for data already in our system. So that's an important thing to understand as you go through the compliance process. The fine, again, I mentioned the fact that this is a human rights law. The fines involved for violating, misusing personal data can be up to 4% of the company's global revenue. So that's a significant fine. Obviously, it's eye-catching and dollar sign catching in a lot of ways, but it tells you how much value the EU attaches to these particular human rights. So I mentioned this was effective on May 25th. Literally about, I think 30 or 40 minutes after that the clock turned in the EU, we saw the first complaint that was filed in this case. And it's no surprise that the complaint was filed against Facebook, as well as Instagram, which it owns, and the WhatsApp app, along with Google's Android. So the whole concept there is that the individual who filed the complaint alleges that Facebook requires everybody to provide all of this data in order to participate in Facebook. It's this concept of forced consent. And we'll focus on that in just a few moments. But the argument right now that Facebook is making is that they need all the data in order to make the program work, because it is a social networking site. And those that filed the complaint say, no, you don't need all of that data. You only need a little bit of data. And so that's where the argument is right now. So it's no surprise that Facebook was probably, again, particularly with what happened here in the U.S. in the winter and spring, about the Cambridge Analytica scandal and all the rest, there was no question that they were going to be, in the crosshairs right away. This complaint is still pending. Beyond that, we haven't seen any complaints of a significant level thus far. Having said that, certainly, the potential of a filing of a complaint exists, and that's really what we're all trying to get our head around and make sure that we're not the ones having a complaint filed against us. So let's shift over now and talk about, again, how that GDPR might apply to you or to your company. A lot of times I will speak with a client, they'll say, oh no, we're just a domestic company. So in our company, we don't deal in anything in terms of EU or any international countries. And just looking at the previous slide there as to whether GDPR applies to you, the answer is likely yes, it applies. As you can see on this slide, customers, and Dolores, if you could just push us back one slide, that'd be great. You or your company, thank you. You likely have customers residing in the EU. You likely may participate in meetings and trade shows in the EU. You may have an office in the EU. But bottom line is you may be open for business to anyone residing in the EU. Even if all your customers are US-based direct, if you got a call tomorrow from a company in Germany wanting to place a very large order, likely you wouldn't turn that down. You would be, quote, open for business. So that also triggers how these regulations would apply to you. So it's very difficult to come up with an example of how GDPR would not apply to a business. I think the best example I can give is, the mom and pop ice cream shop down the street where, it doesn't keep or hold any data, it's cash only, that type of thing. Beyond that, it's going to apply to most of us. So let's look at the next slide because, as I mentioned, the premise of these regulations is centered on the personal data, and it's centered on the processing of the personal data. So the key premise is that you and your companies cannot hold personal data of an EU resident unless you have a, quote, lawful basis, end quote, to process that data. And remember, process even means store it or look at it or use it. So in any inquiry as to compliance with GDPR, the question is always going to be posed, and you'll see this on an upcoming slide. What is the lawful basis on which your company is holding personal data of an EU resident? That's always the threshold question. Now, you can see from this list that there are 6 lawful bases under the regulations. Ones we're going to talk about the most today are the first 2, but let me just go through the others quickly. So you can process the personal data if the data subject has given you consent, or if the processing of the data is necessary for legitimate interests. You can hold also process data when it's necessary to perform a contract. So you get an order and you've got to send goods to a particular person or location. That might be necessary to perform that contract. Processing also necessary if there's a legal obligation, if it's in order to protect vital interests of the person. And the last one really is used in more of an official or governmental capacity in the public interest. So for most of our clients, for most of you listening today, the first 2, potentially 3 of these are likely the lawful basis on which you will assert that you can process the data, the personal data of EU residents. So the biggest misnomer, I think, with these regulations, beyond people saying, well, they don't apply to me, is the fact that we always, in every instance, need to get consent. And that's actually not true. In fact, you'll see as we go through the process that the second item here, legitimate interest, actually covers a very broad scope of data that you may be already holding on your system. So consent isn't always required. It is required in certain instances, and we'll walk through those. But the first 2, consent and legitimate interest, are really the main things to focus on. And as we look on the next slide, just focusing on the legitimate interest itself, the regulations speak to balancing the rights of the person with the rights of the business. But they also say that legitimate interest on, say, your company's part could be direct marketing to an individual, could be unsolicited commercial message, could be sending them a survey or conducting research. But we always have to have a lawful reason to contact that person, and presumably you will, and we have to balance their interests. So in a moment, we'll go through mapping data and what this might look like. But suffice it to say that as you sit today in your database and you have data on current customers, whether they're individuals or whether they are companies, current customers and current individuals that we're working with or communicating with are likely going to fall within the scope of legitimate interest as it relates to your company continuing to communicate with them. And we'll talk about how broad that umbrella could be set up. But the concept of legitimate interest is that we've worked together before and we've worked together recently, and there's a presumption that we want to work together again in the near future. Contrast that with someone sitting in your database that we haven't interacted with in 10 years. They haven't bought anything, we haven't heard from them, etc. That falls outside the scope of legitimate interest. So when we do the data mapping, we always want to look at a data set and say, is there a legitimate interest? Have these people contacted us recently? Have we worked with them, etc.? That's going to be the basis on which we can say that legitimate interest is the lawful basis on which I can keep and hold their data. Now, as I mentioned on the next slide, you'll see consent is the other way that you can process personal data. So it's not that consent is required in every instance, but consent is a way to ensure that the person has affirmatively consented to you processing data. So how many of you potentially, I can't raise your hands because we're on a webinar today, but how many of you in your businesses or in your own personal lives and emails, with it leading into May 25th, we're just overwhelmed with our privacy policy has changed. Please click here, or please see this, please validate the terms and conditions, etc. Companies were really struggling and ramping up, and still are, to try to get up to compliance. And so you've seen a lot of these things, and every company had a different approach on compliance. And I think the reason they do is that there are some companies that deal more with global business and individuals, residents within the EU than other companies. So the risk level for them is obviously higher than the risk level might be for a company that doesn't deal as much in international. So just looking at the concept of consent, consent has to be an affirmative action on the part of the person. So, just thinking of this broadly, a lot of you are familiar with the terms opt-in and opt-out. So many of you, in things that, again, whether you're in your business or personal life or in your company communications, you may have an opt-out. So we may share your information unless you tell us that we can't. This is all flipped for GDPR and for EU residents because really it's an opt-in. And that's an important distinction as to someone doing something affirmative, such as checking a box, in order to opt into communication. So having silence, I saw a lot of these come out by continuing to use our website, you consent our use of your data. Likely that conduct alone isn't necessarily going to suffice for consent that's required, because the regulations say the consent needs to be specific. It needs to say, here's what we're going to do with your data, and if we share your data with someone else, here's how they're going to use it. So that, having silence be an affirmative act isn't applicable, or having pre-checked boxes also isn't applicable. Now, I mentioned a moment ago, or a few moments ago, the Facebook complaint, and I mentioned that concept of forced consent. The regulations state that you can't essentially discriminate, if you want to look at it that way, on an individual just because they refuse to give you consent. So you have to still allow them to access the service. And the exception and the caveat here, though, is that if there is certain data that you absolutely need in order to process their request, then at a minimum they have to give you that data. And if they don't want to give you that data, then you can condition service. So for example, let's say your company has a newsletter that you put out and someone signs up to subscribe, and at that point you may ask them to consent to use of their data and they say no. Well, we can't send you a newsletter if we don't have at least potentially your name and your email address, right, or a street address. So someone who might click a box to say no we couldn't provide that service to you. However, if in signing up for the newsletter, we say you've got to give us 12 pieces of data, all the data about you, where you work, how much money you make, etc. Is that all of those 12 pieces of data? Are all of those necessary in order to give me a subscription or to obtain your newsletter? Probably not. So companies are really forced to determine what data is absolutely necessary to allow us to process what it is you're asking us to do. If you want us to ship you a good, we got to know where to ship it to. So that's sort of the concept there. So again, Facebook is trying to leverage saying, because the secret sauce recipe works when we have all 12 pieces of data, we need them all. And the EU complaint folks are saying, no, you only need 2 pieces of data. So that's really where the argument is. So as you seek to implement potentially consent in your organization, keep that concept in mind about this forced consent. And on the next slide, I'll show you a sample consent. But again, I mentioned consent has to be explicit. One other item on consent, we talked about personal data categories, and that's a very broad set of categories. But there are some types of data which the regulations consider, quote, special categories of data. So this would be data pertaining to someone's race, gender, identity, sexual orientation, national origin, religious affiliation, political affiliation. The things in your mind that you might say, well, that's kind of sensitive. Those are the things which will require an extra consent from that person just on that. So for example, working with a client recently that collects data about someone's race so they can share that in terms of how they're advancing in their diversity efforts. However, in doing that, they have to stop for that moment and say to a person, you don't have to answer this question. If you answer this question, we could use this data for purposes of looking at how we're servicing, each racial community. So we have to be very careful about that aspect of it. So if you do those things, again, keep that in mind. Also, and I doubt this is applicable to a lot of you or your companies, but just in the U.S., so a lot of you are familiar, and potentially you've had this with your own children, that anyone under the age of 13 can't give consent to participate in a website. So in the U.S., a lot of you, if you have younger children that want to participate, on a website, you've got to have the parents' consent, and it has to be verifiable. So you put mom or dad's email address in there. You all get these. You say yes, it's okay. They can use them. It's the same process in the EU regulations. However, the threshold isn't 13; it's 16. In other words, anyone under age 16 has to have verifiable consent of the parent. Now you'll see on this slide, we have a sample GDPR consent. I will just pause here and say that I have seen consents in a variety of ways, built a lot of different ways. There's no magic bullet. However, there are key components to a consent. So when I work with a client, I kind of walk through what it is that you want to do with your data. So again, we'll focus in a moment about what might be legitimate interest and what might need consent. But in a consent setting, as I mentioned earlier, we have to tell the person what it is we're doing with their data. So you see in this example, the first paragraph talks about we'd like to use your data, browsing habits in this case, to share with our company and to provide you with things that are of interest to you. We talk about that data being deleted after 6 months. Pausing on that point, you don't have to put an expiration date in with your consent. Some organizations choose to, but you don't need to. we do have to tell the individual what their rights are under GDPR. In this case, there's reference to you can withdraw your permission at any time in my data. What I have recommended to clients, and we'll talk about this in a few moments, is the privacy policy, is that the nuts and bolts of someone's GDPR rights can be embedded in your privacy policy. So that if you were to look at this as your consent, you might say your data is going to be used as follows. For more information, see, and then we have a link inserted. And that link takes you to your privacy policy. And as we walk through the components of a privacy policy, key consideration are all the rights that someone has to have their information erased or transferred. So all of the nuts and bolts could be parked in the privacy policy, which streamlines the consent. Now again, you see yes or okay, or you see no. If it's no and you see the reference, they could say no, but again, if certain data is necessary to give them what they want, then we have to at least tell them, or we can tell them, look, until you give us this data, we can't process your request. Okay, so let's look at on the next slide. I've sort of been dancing around this concept, but this is kind of taking it from the 30,000 foot and kind of starting to try to descend it a little bit and get more specific. In your organizations, if you haven't done so already, it is important to map your data. And what I mean by mapping your data is really a data review, a data sort. So many companies have opted to say that we're only going to, right now, because these regulations only apply to EU residents, we are not going to apply all of the same standards to everybody in our database. Instead, we're going to pull out those who we believe are EU residents and treat that data set differently than we are everyone else. So that is one business approach to this, because again, right now, it just applies to EU residents. On the flip side, a lot of organizations are saying, you know what, it's easier for us to manage and administer if we treat it across the whole data set, no matter where people reside, and in anticipation that these types of laws or regulations may be coming to the US or wherever else we're doing business soon. So there are two schools of thought on that. Again, what's minimally required is just as to EU residents, but many businesses are doing this across the board. So that's going to be your first consideration. Does your business just want to deal right now in EU residents, or do we want to deal with our whole data set? So just looking across that data set, doing a sort is important. So these are potentially some common categories in your data. You may have your customer data, prospect data, companies or individuals who've been customers before, former customers in recent past, we can talk about recent in a second, or former customers who are long past customers. And then we have a variety of vendors that we might work with for our component parts, or maybe they help us with data backup or security or things like that. So these are the various categories that you have in your database. One thing that's important to understand, as I mentioned earlier, is that these regulations pertain to an individual, not the company. So if you have a German-based company who's a customer of yours, it isn't that company consenting. Rather, it's the individuals with whom you interact in that company who would need to consent. So it's really difficult in a trade situation like you all have in a business B2B situation to get consents as they may be necessary for individuals. However, I mentioned earlier the concept of legitimate interest. If we're talking about a current customer and we're talking about continued communications with a current customer relating to our business, our products, then there's no question that's going to fall within the scope of legitimate interest. So if you took your customer database and you looked at that and said, who are our current customers? If you pull those out, those folks are going to be under the scope of legitimate interest, which means that we don't need consent. We can continue to process any personal data that we have about those individuals. So that's a pretty big sword if you look at it that way. Now, if you or your company work with other companies to say, hey, we're going to share our customer list with you so that you, your company, which might sell a related product, you can market to these people. I'll call that, for purposes of our discussion, external use. Internal use would be me communicating with my customer about my products and services that they bought. External would be me giving that data to another company for that other company to then solicit the individuals. If you are doing any of the external use of data, that's where you're going to need to get consent from the individuals, because the umbrella, so to speak, of legitimate interest only goes so far. It only covers our company and our products and our services, that concept of internal communication. The external side is not covered. So if data is to be used externally, that's when we need an individual's consent. So pausing for a moment, what a lot of companies have done recently is, if they are sharing lists externally of customers, let's say, a lot of them are removing from that list any individuals who they believe to be EU residents, because they may not have already obtained the consent yet. So there's a number of different ways to manage that, but just so you have that as well on your radar screen. Okay, what about prospective customers? Again, we meet somebody at a trade show, they give us their business card. We want to follow up with them. They're a prospect, right? So they gave us their business card, or they reached out to us for pricing information, et cetera. We have a legitimate interest to communicate with them. So now we look at our database, now we look at our prospects, and we say, okay, as to prospects, legitimate interest will pertain to internal communications. Again, if we're sharing our prospect list with another company for them to communicate, again, that's that external use. It's going to need consent. What about former customers? So let's say, and I use this term recent past, when you're sort of mapping your data and you're deciding how wide your legitimate interest umbrella is going to be, is it going to be one of those little pop-up umbrellas with a little narrow top, or is it going to be a nice big golf umbrella, very nice and wide? We need to establish what it means to be legitimate interest when you work with the company. So for example, if I sell parts or equipment that's good for at least 10 years, it may be legitimate interest for me to keep someone's data for at least 10 years, because they may come back to me at any time for service or parts or whatever the case may be. If you're saying, no, my equipment or my products aren't that way, it's probably more like they buy something and then I might hear from them 3 years later. Wherever those years are, wherever those duration is, that's where you're going to draw your circle. So legitimate interest is going to be for individuals that we're currently talking to, and then anybody within a certain circle of time. Again, a lot of companies say 2 years, 3 years, but I've worked with other companies that say, hey, 5 years would be legitimate. It's not uncommon that I might not hear from someone again for 5 years because of the nature of our business or the nature of our products. So there's no hard and fast rule. The only question I have, the issue that I pose to my clients, is to say that however large you draw that circle, be prepared to justify that if you need it. If you're going to say the circle's 20 years, you're going to probably have a harder time justifying that. Whereas if you say the circle's 2 years or 3 years or 5 years, you may be able to justify that. So we're going to need to come up with that, what it means to be recent. But again, now I go back to my customers. When did they last interact with me? Let's say I'm using the 3-year window. If they interacted with my company 3 years or less ago, I'd say that still falls legitimate interest. My prospects, I got their prospect data 2 years ago. So in my 3-year window, I can continue to contact them under legitimate interest. Former customers, again, bought a product 2 years ago, 3 years ago. Now let's say it's a long past customer, again, 10 years ago. We've drawn our circle at 3 years. Now it's going to be more difficult for us to say that it falls into legitimate interest, which means as you're mapping your data, if you have former customers who you haven't heard from in 10 years, your options are either to go to those individuals and try to get a consent, because legitimate interest isn't going to apply, or to remove them from your database. So, these regulations have caused companies to clean up their database, which is good, I think, for a lot of companies. And then finally on this list are your vendors. So you may have data on vendors that you work with. Similarly, our rights to continue to contact with our vendors are going to be based on legitimate interest, and that same scope, whether it's the 2-year, 3-year mark, is going to be applicable to any vendor data. So data mapping is critical. Many groups have done this graphically in their companies. They've gotten a interdepartmental group together, work group together to look at our database, look at the information that you have, and then map it out. What's going to fall under legitimate interest? What's going to need consent? And when we arrive at those that might need consent, then the next question is, how are we going to go about procuring the consent? Are we going to send an email to those people saying, hey, we'd love to work with you again, click here if you consent to us continuing to talk to you, or whether you might have it at the time someone signs up for a newsletter, for example, have a consent built in there. So there's a number of different vehicles that you could procure the consent. All right, I want to shift over on the next slide. I've mentioned privacy policy, and to me, and I'll share with you as we come upon our time, just some things that you can do right away that I would recommend. One of these is having a privacy policy and updating it. Many of you or your companies may have had privacy policies on your website. A lot of them used to say, we don't share your data with anyone. And I see this on a client site and I say, is that true? Well, no, not really. We do kind of share the data. Well, that is a problem now because these regulations up the ante. So privacy policies really should walk someone through, this is how we use your data. This is how we collect your data. This is how we use cookies or other analytics on our websites. These are your rights. And so I've mentioned a few of these already. If I'm an EU resident and you're holding my personal data, I can go to you and say, I want you to erase me from your data. I want you to erase me from your database. So take my data that I gave you, erase it, or transfer it. So we have to let them know what their rights are. We also have to let them know about where data is stored. So who's hosting our website? Who's hosting our data? Even up to company name and even location of companies, which has caused an ire for a lot of companies because they're concerned obviously about security and saying if I say that my data is hosted on a server in Omaha, Nebraska, that's a concern for a company. And I understand that, and the regulations require disclosure of where data is held and hosted, but not necessarily in great detail. So I'm sensitive when I hear a client tell me that we come up with another alternative of saying, where data is stored. Also, the regulations speak to having a data protection officer. While we don't have to name someone specifically by person to person, typically we can and we should. A lot of pundits are out there saying, you don't need a data protection officer. Well, that's true, except for the fact that if you don't have one, the regulations say you got to justify why you don't have one. So my point to clients is have one. That doesn't necessarily need to be a person who's toiling in the IT fields. It really needs to be a person where you'd say the buck stops with this person. This person has authority to deal with leadership. So typically it's a pretty senior person on the team. Again, that doesn't mean that they're in the know. It just means that if someone came to you and said, I want my data erased, and they said, hey, a month ago I asked you to do that and it didn't happen, that's the person that we're going to go to. And what I recommend to clients is to set up a dedicated email address for just the privacy policy. So it might say, for example, privacy@abccompany.com, as opposed to a main email address of someone's. That way, hopefully, that's being separated and monitored in there. So lots of great privacy policy samples out there. I encourage, clients when I'm working on those to talk with their IT folks about what we do or what we don't do. Do we use cookies? How do we use cookies? Do we use analytics? Do we use beacons? Do we use unique identifiers? There's just a lot of the stuff that some of you may be familiar with and others like me kind of said, what is that? So those are things which definitely, in working with the IT team, you want to verify as to what your company does with those things. Now, one last point on the regulations, and again, I know a lot to cover, a lot to digest. Hopefully you've had a few sips from the fire hose here. Vendor contracts. So the regulations say that anytime we let data out our door, we have to do so under the protection of a data processing agreement. And that is to say that if there's a company that has access to our data or a company that we give our data to use, that company needs to we need to have a DPA in place with that company. So for example, let's say you hire a marketing company to regularly contact your current customers. And so as part of that, you give the marketing company that data for them to market to your customers. So in that instance, we always look at these roles, and the regulations say there really are two players here. There's the controller of the data, and then there's a processor of data. The controller simply means it's the person who controls the relationship with the person who gave them the data. So if it's a data on our customer and our customer gave us their data, then we are the data controller. When we turn around and give the data to a marketing company, let's say, we're asking them to do something with that data. That's what the definition of processor is. So there are two roles. So in most instances, if your company shares data of customers or prospects, you're going to be deemed the controller. And in other instances, if you get data in your door, let's say, for example, you get prospect data in your door from some other company, that company is likely the data controller and you are the data processor. So in any given relationship, we always want to assess that. But the key here is everyone understands their roles. Garbage in, garbage out. So we want to have clean data coming in. We know that it's compliant, and we want to have clean data going out. It's a bit like that hot potato game. You know, when the music stops, we don't want to be holding the hot potato of information that we shouldn't hold on to that might be subject to a fine. So these agreements can be amendments to current agreements with vendors, or they can be separate agreements. Most of them you'll see out there are pretty standard. They'll talk about the controller's responsibilities, they'll talk about a processor's responsibilities, and oftentimes processors will have sub-processors, companies which help them process data. So often you'll see reference to sub-processors as well. Most of the agreements are similar, but there are two things that I always look for, and I'll put on your radar screen. The first thing that I would want to look for on your company's behalf is whether the vendor in that situation, whether they're the processor, let's use the example, we're the controller, our marketing company, that contract, that DPA, has an indemnification clause. So simply put, if that marketing company misuses the data, uses it beyond the scope of what we told them they could do with it, and we get hit with a fine, we're going to be kept whole from a financial standpoint. That's that concept of held harmless in an indemnification clause. So a lot of the DPAs you'll see out there don't come with an indemnification. So it's incumbent on your company or your legal ego to look at that and try to build indemnification in. And a lot of vendors will agree to it. A lot of times they want to make that mutual, which you can understand might be reasonable to agree to do. So indemnification, a key component. The other component that I look for, especially if I'm getting a DPA from a company, and a lot of you probably already have received these, is whether that DPA has a limitation of liability clause. And you're going to be able to spot this easily because it has to be in all capital letters. The reason it has to be in all caps is that it has to be conspicuous in order to be enforceable. So what these limitations of liability are essentially what they're called. They're a cap on someone's liability. And oftentimes the cap is set on what we paid the vendor. So again, my marketing company example, a marketing company says, you know, the maximum I'm liable to you is what you paid me last year, which let's say is $10,000. Well, that might be a drop in the bucket if they misuse the data. So at a minimum, I'd like to get rid of these limitations of liability when I see them, but a lot of vendors won't agree to do that. So at a minimum, I like to at least say, okay, the cap applies except if there's an instance where you have to indemnify me. So you messed up, I got sued because you guys messed up. So that $10,000 cap isn't going to apply. So again, these are just some awareness building items to look for. Many companies have already developed their own DPAs and are issuing them to vendors. And that can be a good strategy too, because obviously you control what's in the agreement. So this is going to be ongoing. DPAs, ongoing, signing them, what they say, et cetera. This is going to be an ongoing process because, again, everyone's trying to find their role in here. So as we wrap up, just a couple final points. I mentioned earlier, those of you who are still listening, who haven't gone completely insane, let's hope you haven't. These are some things that you can do right away or your teams can do. And again, some of you may have done this, which is great because then you can check these off your list. The first thing is, as I mentioned earlier, mapping your data, dividing it into categories, and then in each category, determine your lawful basis for each. That's the exercise of legitimate interest versus consent. Put together a consent form and understand where you can use a consent form if you need to use one. Develop your GDPR compliant privacy policy for the website. That can be done pretty quickly, and that should be popped up on your website right away. You don't have to tell customers you have a new policy. A lot of companies are saying, well, do I have to send an email saying our privacy policy has changed, et cetera. You don't have to have it pop up on your website. If you want to, let folks know you've changed it, certainly you might want to put a little banner on your website or something like that, but you don't have to do that. Develop and issue those data processing agreements. One exercise here is looking across all of the vendors that you work with and doing a bit of a triage. Those vendors where we use the most data or have the most access to data get higher priority than those vendors who have limited access to data. And then based on that triage list, we work to get the DPAs in place. And finally, and importantly, checking your cyber liability insurance is important. If you don't have any, get some. If you do have some, couple things. Number one, make sure the coverage amount is sufficient. And here I would say I'd look at coverage starting at $2 million and up. Likely the difference between a $1 million and a $2 million policy is pretty minimal. And given the stakes here, it's worth a higher amount of coverage. And then the other piece is to confirm with your broker that, in fact, GDPR claims would be covered. That's obviously what we would want. But these policies are pretty good. They help groups develop breach incident response plans. They have resources for if you had a data breach and all the rest. So they're good plans. They're good policies to look for. So I would encourage you, if you don't know whether your company has one or not, now's an opportunity to check on that. And then just going forward, on the next slide, just some ongoing care and feeding issues. Again, who's going to be your DPO? Where are we going to list them? What's the process going to be for them to make sure that any requests get handled timely? Training your staff, doing periodic training just so they understand. Again, even just an awareness building is important. Having that incident response plan if there's a data breach. The regulations actually say you have to tell people there's a data breach within 72 hours of the breach, which is fast. For a lot of us, if it happened on a Friday afternoon, it would be very quick. And if we didn't have a plan in place, that would put us behind the 8 ball there. So have a plan. Document what you're doing. A lot of people say, well, where do I go to get certified and all this? There really isn't that process in place. It's a matter of documenting a plan as to what you're doing, your company is doing relative to GDPR compliance. So document that plan. Again, figure out ways if someone does make requests for data, how you're going to administer that. And these last 2 points, as I mentioned a moment ago, make sure the data that comes into your company is clean, meaning it's coming in with the appropriate consent or with the legitimate interest, and make sure the data that's going out of your company that you might be giving to others is also clean. you giving it under the requisite consent, or someone has given us, or we have legitimate interest to share that data with that company. So I know there's a ton of information. You probably have questions. Dolores, I'll turn it back over to you to see if we've had any questions come in the queue while we've been going through the slides. Dolores? If you have any questions, I know Dolores is going to jump in here in a moment. Please go ahead and type them in the chat box. And if you have questions following the session, my contact information is up on this slide. Feel free to shoot a quick email to us if there's a follow-up question. Also, again, feel free to use the slides for some summary. I have additional resource material if you'd like, so just feel free to contact me. And we will have the recording available, as Dolores mentioned, for those of you who want to listen in again or who want to have your teams listen in, are able to do that as well. Dolores, do we have any questions in the queue? I'm hearing none, so I'm just looking in the queue myself. Dolores, I think you're on the line, maybe moving around. If you have questions, again, I'll just encourage you to type those in for us. And again, please consider us a resource here for you and your team. We're all a support group for one another, I think, when it comes to complying with GDPR, and always lots more to talk about in new development. Dolores, I'll turn it back over to you for closing. Well, I think we're having some technical difficulty getting Dolores on the line. This will conclude the webinar. Again, if you have questions, feel free to reach out to Dolores and reach out to me at the email address that you see on the screen. Thank you all for participating today. I hope you have a great rest of the day. And again, please let us know if we can be a further resource. Thanks, everyone.